Compulsory liquidation is a winding-up procedure initiated by an order of the court rather than by a voluntary decision of the company's members. It represents the most formal insolvency process and is generally invoked where the company is unable to continue trading lawfully or has become insolvent. The court supervises the liquidation process to ensure that assets are realized and distributed in accordance with statutory priorities while protecting the interests of creditors and the public. Under Section 122 of the Insolvency Act 1986, several grounds for compulsory winding up exist. The company itself may have passed a special resolution requesting the court to wind it up, even though a voluntary procedure could otherwise have been used. A public company may also be wound up where it has failed to obtain a trading certificate within 1 year of registration, or where it has not commenced business within 1 year of incorporation. These provisions ensure compliance with statutory requirements governing corporate formation and trading. The most common ground is inability to pay debts. A company is presumed unable to pay its debts where a creditor owed at least £750 has served a written statutory demand that remains unpaid for 3 weeks, or where the court is otherwise satisfied that the company cannot meet its financial obligations as they fall due. The court may also order winding up where it is just and equitable to do so, for example where management deadlock, loss of substratum, or breakdown of mutual trust makes continued operation impossible. Several parties may present a winding up petition, including the company itself, the official receiver, the Department for Business and Trade, a contributory, being a person liable to contribute to company assets upon winding up, provided solvency can be demonstrated, and a creditor owed at least £750. This broad standing ensures that insolvency proceedings may be initiated whenever significant public or private interests require judicial intervention. Once a winding up order is made, several important legal consequences follow. Actions by creditors to recover debts are automatically stayed, preventing individual enforcement and ensuring collective treatment of creditors. The company ceases carrying on business except where necessary for the liquidation process, the powers of directors terminate, and employees are automatically made redundant. Control of the company's affairs passes to the liquidator, whose duty is to realize assets and distribute proceeds according to the statutory order of priority. Application of assets. A fundamental principle of insolvency law is that the company's assets must be distributed according to a prescribed statutory order of priority, ensuring fairness among competing claimants and protecting secured creditors while recognizing certain preferential claims. The first priority is given to fixed charge holders, whose security attaches to specific assets and therefore remains outside the general pool available for unsecured creditors. The proceeds from the charged assets are applied directly to discharge the secured debt. The expenses and remuneration of the liquidator rank next because effective administration of the insolvency process is necessary before distributions can be made. Following these costs, payment is made to preferential creditors, including wages and salaries earned during the 4 months preceding liquidation, subject to a statutory maximum of £800 per employee, together with all accrued holiday pay. These preferential rights reflect public policy favoring employee protection during insolvency. The next category comprises secondary preferential creditors, principally Revenue and Customs, HMRC, in respect of VAT, PAYE income tax, and employees' national insurance contributions. After these claims, floating charge holders are paid from assets subject to floating security interests. Unlike fixed charges, floating charges rank behind preferential creditors because the underlying assets remain available for ordinary business use until crystallization. Any remaining assets are distributed among unsecured creditors, including unsecured HMRC claims, who rank equally among themselves under the principle of pari passu distribution. If assets remain after repayment of principal debts, post-liquidation interest is paid, followed by declared but unpaid dividends owed to members, the return of shareholder capital, and finally any surplus distributed among members according to their rights. This hierarchy reflects the principle that shareholders, as residual owners, rank after all creditor claims have been fully satisfied. Administration. Unlike liquidation, administration is primarily a corporate rescue procedure designed to preserve business value and maximize returns for stakeholders while protecting the company from immediate creditor enforcement. Administration therefore represents an alternative to liquidation where rehabilitation or restructuring remains commercially viable. The legislation identifies 3 principal purposes of administration. The first is to rescue a company experiencing financial difficulty as a going concern. Where complete rescue is not achievable, administration seeks to achieve a better outcome for creditors than would likely result from immediate liquidation. Alternatively, the administrator may realize company property to satisfy one or more secured creditors where rescue is impracticable. An administrator may be appointed by the court upon petition, by the holder of a floating charge, or by the company or its directors, provided liquidation has not already commenced. Once appointed, a qualified insolvency practitioner assumes control of the company's affairs. During administration, creditors' enforcement rights are suspended, winding up petitions are dismissed, and no resolution may be passed to wind up the company. All company documents must state that the company is in administration, together with the administrator's name, ensuring transparency for those dealing with the business. The administrator must prepare a statement of proposals for creditors and members, which may be approved through deemed consent, virtual meetings, or other appropriate procedures. Creditors may establish a committee of 3 to 5 creditors to oversee the administration. If approved, the administrator implements the rescue plan. Otherwise, the court may dismiss the administrator or issue alternative directions.